that you had O'Doul's first and then had beer?
Maybe I omitted the beers, but yes.
What?
I omitted the beers.
Hold it. You know what, sir? Don't play fast and loose.
I got it.
Story.
I consume alcohol.
I know that. You lied to them. Did you even have an O'Doul's that day?
Yes.
How many?
6.
And then how many beers? So why didn't you tell them that you had the beer?
I just omitted.
Pardon?
I just didn't. I was afraid of what might happen. I thought I could pass.
Yeah, I would be too, because you're violating your bond condition.
Into the police reports and everything.
It's like a movie. It gets better. Probable cause conference, July 31st, 2025, 9 a.m. Bond continue.
Thank you.
Thank you.
Cinda, I apologize for what I said. Mr. Allen is making me apologize to you also.
Can I have one?
So I'm sorry. Wow, the whole table? I like Getty. Court calls the case, People versus Farage Scott.
And Assistant Public Defender Chanazi Carey, I can rule, Your Honor, on behalf of Mr. Farage Scott.
I didn't know if you were going to do anything today other than that order that was taking forever. All right.
That's 2 things. State your name for the record, Mr. Scott.
Verizon Scott.
Thank you. You're welcome. All right, what are we doing on this?
Judge, I have a green sheet. We are currently working on mitigation for Mr. Scott, so we're asking for an adjournment to continue that.
All right, so you're working on the mitigation.
Yes, Your Honor.
What do you have as bonds? I can look at it, that's all right. I'm just trying to think, how much time are you gonna need to?
I think the 31st should be fine.
Should be okay.
Yes, Judge.
Probable cause conference, and I'm good, Ann. To July 31st, 2025, 9 a.m. Bond will continue.
Thank you so much, Your Honor.
See you later. Calls the case, People versus Devon Haywood.
Anna Mackey on behalf of Mr. Haywood, who is approaching to my right. Please state your name for the record.
Good morning, Your Honor. Devon Haywood.
Thank you.
Your Honor, I believe you reached a resolution in this matter.
You have. And it's here.
Perfect.
That's right. This is the one that, hang on a second. This one, sure, this is the one that I looked at. All right. We have a plea form in this case that the defendant would be pleading to the charge of use of a controlled substance. I don't have, how come these forms aren't that hard to fill out?
Pardon?
How come I don't have the maximum penalty on here of what he's pleading to? Who did this? Mr. Childers? Mr. Childers, type. Childers, you know what? No, you know what? It's typed. Did you type it?
No, I did.
You didn't. Who did?
It was a group effort, but I'll take
I appreciate Ms. Mackey because she provided me with basic love. This is I think we're both at fault here.
It just felt.
She provided me with a mostly typed out plea form. All I did was look at it, sign it, and send it back to her.
Because if it was up to me.
I fill these out myself. I
Correct.
appreciate Ms. Mackey doing my work for me. I'm not gonna, stop there.
Well, she half did it.
Yeah, and so we will.
I wasn't going to put a max penalty for my client.
What?
It felt wrong to like do that part. So I was like,
That hurt. I just couldn't write that. I couldn't type that part. What is the maximum penalty on the one that Pardon?
1 year.
1 year, 2000. It was a group effort. Like how they all sat there and tried to protect each other. All right. May I have him sworn?
Solemnly swear in affirmative testimony you're about to give the truth, the whole truth, so help you God.
I do.
State your name.
Devon Haywood.
All right. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of use of a controlled substance. That's a misdemeanor, punishable by up to 1 year incarceration and $2,000 fine plus court costs. Do you understand that, sir?
I do, Your Honor.
Do you understand what a no contest plea is?
Yes, I do, Your Honor.
All right. Two things about it I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
I do.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
I understand.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
I do.
All right. Basis for the no contest plea?
Civil liability, Your Honor.
All right. And sir, to this charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
I do.
You signed an advice of rights form, is that correct, sir?
Yes, sir, Your Honor.
Do you have any question regarding any of those rights?
No, sir, Your Honor.
All right. Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
I am. I'm on probation for, explain the case.
Well, were you on probation at the time of this offense?
No, Your Honor.
All right.
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Has anybody threatened you or coerced you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
All right. The court has been provided Washington County Sheriff's Office report, and I've also reviewed that report for their case number 2442704. Any objection to the court having reviewed that report?
Okay.
None from us, Your Honor.
All right. Sir, you also understand that if between the time I accept your plea, if I accept your plea, and the time of sentencing, if you commit misconduct as defined by the court rule, two things would occur. You would not be entitled to set aside your plea, and the court would not be bound by any sentence agreement and or evaluation of your case. You understand that, sir?
I do.
All right. Based upon the review of that report, the court does find that there is a sufficient factual basis in which the court could determine the defendant's guilt. Before I accept his plea, is counsel aware of any other promises, threats, or other inducements which have caused this plea?
Not yet, people.
None, Your Honor.
All right. Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
August 14th, 2025 at 10 a.m. in Judge Washington.
August 14th, 2025. What time?
10 a.m.
10 a.m. before Judge Washington. Bond will continue.
Thank you, Your Honor.
Thank you.
Thank you. Thank you, sir. Court calls the case People versus Derek Stevenson.
Jacob, can I be asked the people, Your Honor? All right, before we'll hear from people.
Michael, he just.
How you doing, sir?
My apologies, Your Honor.
Michael Gaddy, Assistant Public Defender for Mr. Stevenson.
Your name, sir?
Derek Stevenson, how you doing, Your Honor?
I'm doing well. Thank you, sir.
Yes.
Your Honor, we have submitted a green sheet in this matter. We'd ask for a brief adjournment so that we can obtain video discovery.
Probable cause conference will be adjourned July 22nd, 2025, 9 a.m.
Thank you, Your Honor.
Bond will continue. Thank you.
Thank you.
Court calls case People versus Michael Frazier.
Public Defender Chelsea Regiles with and on behalf of Cyrano Johnson. Mr. Johnson, please state your name.
Cyrano Johnson.
I mispronounce your name every time, sir. And I apologize.
Thank you, Your Honor. Today is the time and date set for a probable cause conference. Regarding that, we are asking for an adjournment to show compliance with his bond conditions. I understand he's had a violation that we are prepared to deal with today.
All right.
Mr. Johnson is prepared to plead guilty to violating his bond by consuming alcohol on July 7th.
And I'll accept that. Before imposing any sentence regarding that, I'm going to ask this question. He presumably, he has indicated that he had O'Doul's. So my only question is, does your client wish to stick to that story, or does he wish to tell me the truth?
I believe that he would not be sticking to that story, that he would be stating that he consumed beer.
That is correct, Your Honor.
Then why'd you tell everybody O'Doul?
I had O'Doul's first, but I needed beer.
You had O'Doul?
Yeah. I don't look like what I'm going through.
No.
I had O'Doul's.
Are
but
you
I had beer.
tell me that? So did you tell them that?
Yes.
That you had O'Doul's first and then had beer?
Maybe I omitted the beers, but yes,
What?
I omitted the beer.
Hold it. You know what, sir? Don't play fast and loose.
I got it.
Story.
I consume alcohol.
I know that. You lied to them. Did you even have an O'Doul's that day?
Yes,
How many?
6.
And then how many beers?
2.
So why didn't you tell them that you had the beer?
I just omitted.
Pardon?
I just didn't. I was afraid of what might happen. I thought I could pass.
Yeah, I would be too, because you're violating your bond condition.
Indeed.
So first of all, we did the calculation because the only story you gave is that you had O'Doul's. To get to the level that you were at, you would have had to have 25 O'Doul's in an hour
No, I didn't have
in
that.
order to reach that level,
Sure.
and could not have used the bathroom because you couldn't eliminate in order to get to that level. That's how stupid your story was. And now you can't even, you can't bring yourself to say that you were intentionally lying to them and attempting to mislead them. It was not just a simple omission. Counsel, what did you want me to do with this case?
Regarding the probable cause conference, we're asking for a 2-week adjournment so that he can show that he's going to comply with the court's orders. I
Well,
understand.
I don't think he's going to have a choice on that, quite frankly, Mr.
Yeah.
Allen.
We are asking for him to remain out of custody today. This would be his first bond violation. He is here to be honest with you, although the truth doesn't always make sense.
Really?
He is.
Really?
He's here.
No, he was not being honest. I asked him the question and then asked him the question of why didn't he tell them? And he couldn't even be honest about that. I'll let you go ahead with your argument, but I'm not buying any of that.
Your Honor, he is honest about the fact that he consumed alcohol, and he is very open to treatment. He understands that he has a substance issue and he wants to get help for that. Your Honor, he's a business owner. There's a lot of pressure on him. He provides for himself and his family. He also does volunteer work, not court ordered, just out of the goodness of his heart. He is open to treatment, substance abuse, counseling. He plans to seek that regardless of whether the court orders it or not. We're asking you to keep him out of custody with a scram tether. Again, this would be his first violation. And he is asking for the opportunity to show compliance while out of custody.
Anything from the people?
Your Honor, we do have some concern about Mr. Johnson's ability to comply with the bond conditions. As stated, this is his second offense. I think it's just a couple of years. We would note that in this case, he allegedly was found not awake in a vehicle that was in the street with 2 guns on him, although he's only charged with 1 CCW. So we do have some concerns about whether he's able to comply with those bond conditions.
Anything else?
Yeah, I just think that he would have a better opportunity to get the treatment and help that he needs out of custody.
He first has to admit that he has a problem.
I
The
do.
way that he does admit that is he stops lying. Defendant's bond at this time is revoked. Defendant's remanded. Court does call the case, People versus Fred Willis.
When you're going to go to the people.
And Alex Warren Green on behalf of Mr. Willis. Mr. Willis, can you state your name for the court, please?
Fred Willis.
Thank you. Your Honor, today's the date and time for probable cause conference in both of these matters. I have completed 2 adjournment request forms. We are requesting to adjourn both cases. We need to complete discovery in the discharge at a building case.
Got it.
Thank you.
July 22nd, 2025, 9 a.m.
Thank you, Your Honor.
Thank you. Bond continued.
Mr. Captain, case, I move file that to move his date to the 17th.
Yes, sir.
Court does call the case of the People versus Stephen Johnston.
Laura Yagi, Assistant Public Defender, hopefully with and on behalf of Mr. Johnson, who indicated to me that he was on Zoom. Okay, Mr. Johnson, can you unmute and state your name for the court? Thank you. Your Honor, I am asking for an adjournment in this matter to continue conversations regarding the next step in the case.
Probable cause conference will be adjourned to July 22nd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Your Honor. Thank you, sir. Court calls the case People versus Alvin Jones. Ms. Weidling, if you could let Mr. Giles know. All right.
And Assistant Public Defender Nicholas Bukovich on behalf of Mr. Jones, who should be appearing via Zoom. I did see him earlier.
Yeah, I see him, but, well, I see the A.
Mr. Jones, you can please turn on your camera and microphone and state your name for the court.
Bukovich.
As my client is I did see him on Zoom and it's been indicated by the court he is on Zoom. I would ask for a brief moment to pass this to see if I can help him get his technology working, because I did see his camera on earlier.
Okay.
Alvin Jones.
How are you gonna do that? Oh, is she calling? Cannon gets involved, bad things happen.
I will call him myself.
Okay, good enough. Just saying. Court calls the case People versus Anushka King.
Great introduction, Your Honor. Cannon on behalf of Ms. Anushka King, who is here to my right. And Your Honor, this is a plea agreement.
Yes, it is. Your name, ma'am?
Anushka King, Your Honor. Good
All right.
morning.
The plea agreement that I have indicates that the defendant will be pleading guilty to the charge of operating with a high BAC second offense. That is a misdemeanor punishable by up to 1 year incarceration. There's further an agreement, and that's count 4. Then what counts 1, 2, and 3 would be dismissed. The defendant is also agreeing to complete screening at the 16th District.
36.
So-
Yes,
It's 30, it's 36. They made a mistake
Is it-
on paper.
No, I didn't. It's 16.
It says 16.
36 wouldn't take the transfer.
Oh, okay, thank you. Okay,
Your Honor, she will complete one, yes.
yes.
What?
She will be completing the one at the 16th District Sobriety Court.
So we're all in agreement to 16.
Yes, we are.
All right, 16th District Sobriety Court, including submission of all required documents, participation in all required interviews and assessment, contravention of acceptance or denial must be forwarded to the APA. That is the court's full understanding of the agreement. I am going to check box 5 on this form, which is the sentencing judge waiver. Did she read that over, counsel?
Correct, yes. Yes.
Okay. May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Anushka King.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of operating with a high BAC second offense. That is a misdemeanor punishable by a $200 to $1,000 fine plus court costs, 5 days to 1 year in jail. The court could order community service and any rehabilitative programs the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that?
I do.
All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Washington in the 14B district court.
I do.
You understand that?
Yes.
All right. Now, understanding all of that, you still wish to plead guilty.
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights.
Understand?
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you are indeed guilty of this offense?
I do.
March 3rd, 2024, at the location of I-94 near Wired Road in Ypsilanti Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
I was.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
I did.
What did you have and how much?
A couple of shots. I don't remember in some coolers.
Pardon?
A couple of shots. I don't remember exactly how many. And I had 2 coolers.
Shots of what?
Tequila.
Okay. Were you stopped by the police or was there an accident?
I was stopped.
All right. Why'd they stop you?
I run around a semi truck. I get panicky around semi trucks. I sped up and I went around him to get ahead of him because it was construction in the area. And I was
Okay. So
speak like
there was some type of erratic driving?
Speed violation, yes.
Okay, you're not disputing the right of the police to stop you in this case?
I'm not.
All right. After they stopped you, were you ultimately arrested?
Yes, they took me to the hospital.
And there was a blood draw?
It was blood draw.
And what was your
Your Honor, if I may,
results?
the prosecutor and I have agreed to stipulate to the findings of the Lansing Forensic Laboratory forensic report, laboratory number TX 24-3306, whereby it was found that.
I just need a number.
Oh, sorry, Your Honor, 0.216 grams of alcohol per 100 milliliters of blood. Well, we were stipulating to the findings, Your Honor, my apologies.
No, it's okay. I was gonna let you go, but
Okay.
I ain't got all day. All right. Ma'am, do you have any reason to dispute those results?
I don't.
All right. Had you previously been convicted of operating while impaired on or about April 5th, 2022 in the 23rd District Court, and or of operating while impaired on or about February 16, 2021 in the 43rd District Court?
Yes.
Yes?
Yes.
All right. Counsel, are you aware of any other promises, threats, or inducements that have led to this plea?
None, Your Honor.
All right. And ma'am, I do have to advise you that if I do accept your plea and you commit misconduct as defined by the court rules, any evaluation of your case, the court would not be bound by that, any evaluation, and you would also not be entitled to set aside your plea. You understand that?
I do.
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
You have, Your Honor.
Court will accept the defendant's plea to count 4. Counts 1, 2, and 3 are dismissed. Pre-sentence investigation and report is ordered at 14A or 14B probation. Sentencing in this matter will be
August 14, 2025 at 10 a.m.
August 14, 2025, 10 a.m. before Judge Washington. Bond with its conditions will continue. Thank you.
Thank you.
Thank you, Your Honor.
Do you want me to fill out a sheet for that? Don't have to see.
That was nice of you. You usually don't share. Court calls the case, People versus Romeo Smith.
Rachel McDuffie for the people.
Assistant Public Defender Jay Bellinger on behalf of Mr. Smith, who appears via Zoom from the jail, Your Honor.
Yes.
It looks like he's muted.
He is.
Mr. Smith, can you please state your name for the record?
We're having a Martez Smith.
All right. Thank you.
Your Honor, we are here for a competency review hearing today, and I suppose I can let this serve as information to the court and everyone around me. I reached out to a couple of contacts at the CFP, and they responded back to me with the following, and that due to limited bed resources and increased demand throughout our hospital system, there are extended delays in our admission process. As a result, we anticipate that Mr. Smith will be admitted for competency restoration treatment in approximately 1 to 2 more months. I contacted them about several other clients, and they gave me the same exact response. So I wanted to let the court know that. It's very unfortunate, certainly, but that's what they gave me.
Okay. That's my last date in August is what?
August 19th.
Then a conflict does exist, given the waivers, the court will consent to hear the matters. The court does call the case of the People versus Jennifer Lindsley.
Andrew Childers appearing on behalf of the people, Your Honor.
And good morning, Your Honor. Laura Yagi, Assistant Public Defender, with and on behalf of Ms. Lindsay. Ms. Lindsay, can you state your name for the court?
Jennifer Lindsay.
Oh, thank you.
And Your Honor, I am asking for an adjournment in this case. I did get an offer, but I need some time to meet with Ms. Lindsay and discuss it.
And she's at Huron Valley?
Yes.
Are you able to get in to meet with her? I mean, I know there were some issues and I just want to make sure.
So I filled out the application. I don't have a specific meeting confirmed yet. But I'm going to try my best.
All right, I got you. Okay, because of scheduling, it'll be July 31st. Probable cause conference adjourned July 31st, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor. And I do have the sheet. Sorry. Thank you.
Now, court does call the case of the people versus Anthony Lafredo.
Good morning, Your Honor. Karma Dadush on behalf of Mr. Lafredo. Mr. Lafredo, can you please state your name for the record?
Anthony James Lafredo.
Thank you, sir.
Your Honor, we are going to be binding this case over to circuit court. There is an offer on the record and we would like to, an offer in circuit court.
Doing what?
We would like to please have this bound over to circuit court. Waiving preliminary examination.
Told you that. Canon?
No, it was this
Daddy?
case. I don't know why I always
Mr.
have
Daddy?
problems with preliminary
I didn't know who you were
examinations.
parroting, but go ahead.
Parroting myself, my own brain. Sorry about that. This is not even the end of it. The end of the issues. Mr. Lafredo is in.
Why do I have to start with you?
You started with Yagi. And
I know, and that was quick. This will
not be quick, unfortunately. Mr. Lafredo is in Jackson County Jail. I have not been approved yet, even though I submitted that pretty early, to talk to him to be able to get his signature for the preliminary examination waiver. Do we need to adjourn, or am I able to ask him if I can sign on his behalf on the record?
Mr. Lafredo, you're waiving your right to a preliminary examination.
Yes, sir.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
I do understand.
All right. You understand you will not have that hearing and that you'll proceed to circuit court for further proceedings.
Yes, Your Honor, I do.
All right. People also waive the right.
We do, Your Honor.
You can just, she can affix your signature to the form, sir.
Absolutely. Thank you.
And for the record, Ms. Pirani met with him a couple of days before. So it's not like someone, another APD met with him regarding this case and went over all of this with him. So this is not, just because I didn't meet with him this week doesn't mean he doesn't understand what is happening today. Because we discussed that with him earlier. I just want to put that on the record.
That is correct.
Understand?
He does, yeah. Thank you, Mr. Lafredo.
Is there anything else?
Nothing further.
All right.
Thank you.
Preliminary examination having been waived. Defendant is bound over to circuit court on the single count.
Thank you, Your Honor.
Thank you. You guys have a good rest of your day.
Hold on.
Oh,
now you don't want to talk. Your turn.
We waive formal reading of the charges in SAMU.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be set for
September 3rd, at 1:30, with Judge Conlon.
September 3rd, 2025, 1:30, Judge Conlon. Bond in this matter will continue. Thank you, Mr. Lafredo.
Thank
Your
you.
Honor. Thank you, Mr. Lafredo.
Court does call the case of the people versus Brandon Kelly.
Thank you, Mr. People.
Assistant Public Defender Chelsea Vergils with and on behalf of Brandon Kelly. Mr. Kelly, please state your name for the record.
Brandon Isaac Kelly.
Thank you.
Your Honor, today we are asking for an adjournment to continue a plea discussion and allow me to do an AIM referral. I am also asking to address bond.
Probable cause conference will be adjourned July 22nd, 2025, 9 a.m. Bond.
Thank you, Your Honor. Regarding bond, his bond is currently a 5,010%. We're asking you to consider a personal bond. Mr. Kelly does stay in Washtenaw County. He has an Ann Arbor mailing address. He reports that prior to being in custody, he was engaged in community service. He does not have a criminal history. He understands the bond conditions not to go back to target or have contact with the complaining witness. He does have another case open, but it is my understanding, based on the record on JIS, that $100 bond will turn into a personal bond upon his release on this case.
So he's held on another matter.
Yes, but if this were turned into a personal bond, that would automatically turn into a personal bond.
That the way the bond reads?
On JIS, it does state that Magistrate Garwood said it that way.
People believe that the bond term set is very fair and appropriate. In other cases, other unprovoked, most of the cases that has consist of him being in public places and just punching people in the face, either because they looked at him or he looked at them. In this particular case, he had the use of the watch as makeshift brass knuckles, which escalated into a felony. These cases happened within about 3 weeks of each other in the month of June. I'm not really sure what's going on with Mr. Kelly, but I'm not the most stable at this point. And I would request that.
So was he on bond on the other case when this happened? Not yet. All right. Anything else?
No, thank you.
Court does believe that the bond is set appropriately. Motion for bond reduction is denied. Bond will continue. Thank you. Court does call the case of the people versus Benjamin Hoffman.
Ally Zend on behalf of the people, Your Honor. And Your Honor, maybe in the hall, I'll go grab them.
Okay, so the people versus Sean Bilodeau.
Good morning, Your Honor. Edward Dukas on behalf of the defendant.
Sean Bilodeau?
Your Honor, there's an outstanding DVD I need to obtain. I'm asking for just a brief adjournment.
Probable cause conference, July 22nd, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Where are they? Okay, court does call the case people versus Jacqueline Jones Washington, all three cases.
Mackie on behalf of Mrs. Washington, Jones Washington. Mackie requesting permission to practice under Michigan Court Rule 8.120 under Public Defender Brian Bowling.
Permission to practice is granted.
Thank you, Your Honor. Appearing on behalf of Jones Washington, she's in custody.
Yes.
Oh, she's on Zoom.
Could you state your name, please?
Jacqueline Jones Washington.
Thank you.
We are still waiting for a competency report in this matter, Your Honor, so we respectfully request an adjournment.
I have one that is
So I saw in
dated
July.
June 17th.
I have one as well.
You have that one as well?
Found that.
Our office hasn't had one since May.
Got it.
So this is the report on the 2025 case. So she needs a higher one.
Got it. Okay. My staff just reminded me, this was the case where she had been, I think, found incompetent but restorable on two of the matters. We needed a new order for the third case, the 2025 case. This report that just came through, which has the same finding of incompetent but restorable, is the same as the other one. Does that make sense to you? I recall having to do this. We just didn't have an order for the 2025 case.
Okay, so did you need that order? It was sent last time, I believe, right?
Well, we didn't have the order for the forensic exam. So we did that.
Yeah.
This is the report this current report, which is effectively the same as the other reports, is coming from that new order that we sent for the request for the preliminary examination. Ms. Akinwumi, was there something you were going to add?
Absolutely. I'm just taking notes, Judge. I just wanted to make sure I was catching.
What do you mean you're just taking notes? Just gonna.
As far as people go, we would stipulate to the findings of the report that Ms. Jones Washington was.
If you, okay, and I don't know if you're in a position to stipulate to it. It's the same, it's the same finding, but I don't know if you feel that you're gonna need to go through it with your client.
Can I have a 2-week adjournment so I can review that report with my client? Okay.
I'll adjourn all of these matters. I'll adjourn the competency to July 22nd. Well, we're not going to be able to get it back because that's not 2 weeks. It's going to have to be July 31st, 2025, 9 a.m. Bond on all of these matters will continue.
Thank you, Judge.
What is that date again? If you can please repeat that.
It's July 31st,
And
9 a.m.
9 a.m. Thank you so much.
All right, got it?
Yeah, thank you.
Thank you. Court does call the case of the people versus Rio Boyd.
So, Mrs.
And then on behalf of the people, Your Honor.
On behalf of Ms. Boyd, would you state your name for the record? Oh, sorry about that.
Riel Boyd.
Judge, I was just appointed, I think yesterday, may we get a short adjournment?
Probable cause conference will be adjourned July 22nd, 2020, 9 a.m. Found continued.
July 22nd. Thank you, Judge.
Thank you.
Thank you.
Okay. Court does call the case of the people versus Duran Wilburn.
Alizan on behalf of the people, Your Honor.
Edward Lucas on behalf of Jerome Will approaching.
And good morning, Miss Lowe. Just because you think that you're a small walking past, I could still see. Your name, sir?
Ron Wilburn.
Thank you.
Your Honor, at this time, discovery is complete to my knowledge. I'm asking for a preliminary examination.
20 seconds. Would the people have their witnesses available the 22nd?
We'll do our best, Your Honor. And I did want to make clear aware as well, we did request a 911 call on the 9th, so it should be here before exam.
All right. Preliminary examination in person, July 22nd, 2025, 9 a.m. That is before
Judge Barr.
Judge Barr. Bond will continue.
Thank you.
Thank you. Court calls the case people versus Daisha Moore.
I'm here. Good morning, Your Honor. Christina Costantino appearing on behalf of Ms. Moore. Ms. Moore, can you please unmute and state your name for the court? Deja Moore.
Thank you, ma'am. Constantino, you just don't come to like Washtenaw County anymore?
Judge, I love Washtenaw County. I would much rather be there with you than where I've been. Trust me on that one.
Okay. All right. Well, everybody else misses you. I don't. All right. What are we doing? What are we doing?
Judge, I did just recently receive some new discovery this week. I would like a chance to review that with my client. So we would be asking for a brief adjournment of the PCC.
All right. We have some strange dates. Would you like Tuesday, the 22nd or the 31st?
The 22nd would work.
All right. Probable cause conference will be adjourned July 22nd, 2025, 9 a.m. Bond continued.
Thank you, Judge.
Right. Thank you. It does call the case of the people versus Isaiah Bozeman.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Bozeman. State your name.
Isaiah Bozeman.
All right, what are we doing?
We're requesting an adjournment to review discovery.
Are you, it's not signed, but are you aware of a character reference letter sent on his behalf?
I don't have that, Your Honor, no.
All right, I'll make sure because since it came to the court. How many things? Yeah. That come with it?
Something to you somewhere.
I don't know why they're here. There's a number of them sent for whatever reason. There's not going to have an influence on the court, but we'll provide those to both parties.
Thank you, Your Honor.
All right. You're asking for an adjournment of this matter. I'll adjourn this matter. Probable cause conference to July 22nd, 2025, 9 a.m. Bond continued.
Adjourn.
Court calls the case of the people versus Heather Booth.
People.
It's rushing.
Oh, great.
Good morning, Your Honor. Sydney Rushing, appearing on behalf of Miss Booth. Is that Miss Booth in the Wayne County Jail by chance? That's where she is currently located, Judge.
Do you have her?
We did not know she was in custody.
We did not know. So I'll have to kick this out to the 31st. So we have the 2 weeks for a writ if she's going to be there.
Your Honor, she's on remand status, so it's my understanding that she's likely going to remain there till then.
Okay. Probable cause conference July 31st, 2025, 9 a.m. Bond continued.
Thank you so much, Your Honor.
Thank you. Court does call the case of the people versus David Mariquin, 2 cases.
Your Honor, Alex Warren Green on behalf of Mr. Mariquin. Do you state your name?
David Mariquin.
Thank you.
Your Honor, at this time, we're asking the court to set both matters for preliminary.
All discovery is complete.
Discovery is complete, Your Honor.
People have their witnesses available the 22nd. Preliminary examination in person in these matters will be set for July 22nd, 2025, 9 a.m. 9 or noon?
It's actually at 12.
12 noon
With you.
for me. Bond will continue.
Thank you, Your Honor.
Court does call the case of the people versus Todd Amerman.
And Lori Yaki, Assistant Public Defender with and on behalf of Mr. Amerman, who is standing to my right.
Your name, sir?
Todd Ammerman.
Your Honor, I do apologize. I will 100% take responsibility. We do have a plea form. I know I should have submitted it yesterday. Mr. Ammerman was very diligent in calling my office and we were only able to connect after. But we have agreed upon a plea. It's not a no contest. It's just a guilty plea to an added count 2 abuse. So I'm hoping the court will take this today.
Plea form indicates that the defendant will be pleading, that box was a check. He's pleading guilty.
Yes, I apologize.
That's what happens when we rush things at the last minute. The plea form indicates that he's going to be pleading guilty to the charge of use of methamphetamine. On his successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
Yes, Your Honor.
That's correct.
Let's have him sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Todd L. Ammerman.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Do you understand that?
Yes, sir.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Freshour in 14A4 District Court.
Yes, sir.
Understanding all of that, do you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
Has he signed an advice of rights form? You're not ready. I'm passing it.
Okay, I'm sorry.
Court calls the case, People versus Zavratko. Get enough, I think.
Good morning, Your Honor. Warren Miller, on behalf of the people.
Good morning, Your Honor. Roba Hamden requesting permission to practice pursuant MCR 8.120 under the supervision of Assistant Public Defender David Boundary.
Permission to practice is granted.
Thank you. I am here with on behalf of the Gravo Kitnell. Can you please state your name for the record?
Sure, Kitnell.
We are requesting a 2-week adjournment on this matter for negotiation.
Probable cause conference will be adjourned July 22nd, 2025, 9 a.m. Bond continued.
Your Honor.
Court calls case of the People versus Anita Barnes.
Assistant Public Defender Nicholas Bukovich on behalf of Ms. Bonds, who should be appearing via Zoom.
Anita Barnes.
Got her? Yeah. All right, what are we doing?
At this time, Your Honor, we'll be requesting a 2-week adjournment for a bit of further negotiation, and so I can provide some documentation to APA Cook. And I do have a green sheet.
Probable cause conference will be adjourned July 22nd, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Ms. White. Court does call the case, People versus Anthony Alfaro Cajellas.
May it please the court, Your Honor. Good morning. My name is Venu Yadala. I appear on behalf of Zachariah Bonham, who is the attorney of record.
Oh. Is he here?
I'm sorry, Your Honor.
He's in custody.
Hey, how you doing?
Your name, sir?
Anthony Alfaro Callejas.
Thank you. All right, what are we doing?
Your Honor, my understanding is that counsel just submitted a substitution and needs time to give discovery or give the client. So I believe they're requesting an adjournment.
Your Honor, that is a fair and accurate statement. Negotiations are being continued. We would respectfully request a brief adjournment.
They didn't tell you anything about green sheets. You'll need to fill out the green sheets. I'll grant the adjournment. But would the 22nd be enough time, counsel?
Thank you.
Will that be enough?
That should be enough. Thank you.
Probable cause conference will be adjourned July 22nd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls case People versus Roderick Bates.
Assistant Public Defendant Nicholas Bukovich on behalf of Mr. Bates, who should be appearing via Zoom.
Good morning,
Your name?
Roger Bates.
So, Your Honor, the prosecution's recently provided some additional video discovery we were just able to get from Washington County, so I just need time to review that with my client, so I'm requesting an adjournment.
Probable cause conference. Do you have a green sheet from?
Yes, I do, Your Honor.
July 22nd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Thank you.
Court calls the case of People versus Molly Fox.
Good morning, Your Honor. Ellen Dennis appearing on behalf of Molly Fox.
Your name?
Molly Fox.
You're requesting, well, is she gone to inpatient treatment yet?
She hasn't gone, she's still in custody, Your Honor. You
I know.
signed the order yesterday, I think. And it has some contingencies in it that there has to be a bed. She believes there will be, but we don't know yet. Also, I could tell the court that she's been interviewed by Mr. Reyes with a review of whether she'd be eligible for recovery court. And I do not know what that decision is because I haven't received the email yet from him. That happened, was it yesterday? Day before yesterday? Tuesday.
Your interview happened day before yesterday?
Yeah.
Okay, they should be coming out, hopefully with a decision relatively soon. I can give you the 22nd or the 31st, counsel.
Pardon?
The 22nd or the 31st, which date would you prefer?
The 31st. Now, I assume that if the bed becomes available, she can go and still.
She'll be an inpatient and we'll deal with it, but I mean.
Okay.
I'm not going to hold everything up on that. Probable cause conference, July 31st, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Your Honor.
Court calls case People versus Elton Bell.
Good morning, Your Honor.
Kerma Dadush on behalf of Mr. Bell. Mr. Bell, can you please state your name for the record?
Elton Robert Bell.
And good morning, sir. All right, what are we doing?
Your Honor, I did submit a green form, but we are actually not going to be adjourning on this case. We are going to be waiving preliminary examination.
All right, Mr. Bell,
Yes,
you're going to waive your right to a preliminary examination?
yes,
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
yes,
And you understand you'll not have that hearing, you'll proceed to circuit court for further proceedings.
yes,
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant bound over on a single count.
We waive formal reading of the charges and stand mute, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
August 28th, 2025 at 1:30 with Judge Slay.
August 28, 2025, 1:30, Judge Slay.
Thank you so much, Your Honor.
thank you, Your Honor.
Bond will, thank you, sir. Bond will continue. Court calls case People versus Ardeen Henderson.
Just about two people.
Hey, everyone.
Kerma Dadush on behalf of Ms. Henderson. Ms. Henderson, can you please state your name for the record?
So my name is Ardeen Beatrice Henderson, Grand Rising. Thank you all for having me.
You're welcome.
Your Honor, we are going to be asking for an adjournment. We have just started a mitigation process. So we're going to be asking for an adjournment for that purpose and plea negotiations.
Your Honor, I would just remind the court, this commission does have a case in Wayne County. She's got a case at 35th District Court, where she's referred for competency in May. That court did not come in based on her actions. And that court is for August 29th.
August 29th. So were you aware of that, counsel?
Yes, I was. She had told me that she started that process.
Okay, well, then I'm a bit reluctant to do anything prior to that competency report coming through. So
Are we able to adjourn further out?
I'm able to do a lot of things. Some of the things I will not do.
Whatever your honor prefers.
Of course, you're learning. Give me a September date.
September 11th.
September 11th.
Can she hear it?
I will adjourn. Yeah. Can you hear me, ma'am?
Yeah, I just don't understand what's going on. Can somebody please explain to me, please?
Okay, so I'm adjourning it out. Okay, my understanding is that there's a competency review in your other matter.
Okay.
Okay, so
Okay.
what we're doing is we're taking the safe course of this, putting this out till after there's a finding there, because that may dictate what happens here. We really can't get much done until that comes through.
Okay, well, my lawyers better explain to me later also again, I won't forget, or can someone send me something or something if I can have someone read to me what's going on? Okay, never mind. The sergeant here said, Sergeant Perzan, how you pronounce your name? Porzandek said he'll help me. He explained to me.
Okay, and your attorneys will be in touch with you, okay?
I can talk to you next week, Ms. Henderson, okay? To explain all of this.
Thank you.
Okay.
I thank you all for having me.
Yes.
Okay,
we are so glad, and we will
thank
have you
you.
back in September 11th, 2025 at 9 a.m., okay?
Take care, Ms. Henderson.
Ron, continue.
For my birthday, and what day would, I'm
That's
sorry,
your
what
birthday?
day would that be?
September 11th.
September the 18th, that's right before. Okay.
September
That's on the
18th, your birthday? Well, so I
Yes.
don't forget, happy birthday.
Thank you. I'm taking my grandkids to the water park before it gets cold. Thank you.
Okay, take care.
Thank you.
Court calls the case, People versus Orby Huffman.
If you ever take it to people.
David Burgess on behalf of Orby Huffman.
State your name, sir.
Orby Huffman.
Thank you. What are we doing?
Your Honor, we've received discovery in this matter. We're requesting an exam be scheduled.
People have their witnesses available the 22nd. Preliminary examination in this matter will be set for July 22nd, 2025 at 9 a.m. before Judge Barr.
Thank you, Your Honor.
Bond will continue. Thank you. Does call the case of the People versus Nathan Bell.
People.
Assistant Public Defender Nick Bukovich for Mr. Bell, who should be appearing via Zoom.
Nathan Bell, do we have him?
No, I do not.
I was in contact with my client this week and he asked me for that Zoom request.
He did?
Yes.
I'm here.
So,
I'm here.
He goes by another name, Motorola. Sir, I need you to turn on the camera, please. Yes, sir. Yes, am I here? Yes, I'm here. You have to uncover the lens. There you go.
There you go.
What's your name? Nathan Bell. All right, what are we doing?
I'll be requesting a brief adjournment. Firm is about to obtain some medical documentation I can provide to the prosecution towards an offer. And I do have a green sheet, Your Honor.
July 31st, 2025, 9 a.m. Bond continued. Court does call the case People versus Jonathan Miles. Oh, there she is. Okay.
Good afternoon, I'm sorry, good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Good morning.
And Alex Warren Green on behalf of Mr. Miles. Mr. Miles, can you state your name for the court?
Jonathan Dion Miles.
All right, what are we doing?
Your Honor, I had an opportunity to confer with the Assistant Attorney General. She did extend a generous offer, but at this time, Mr. Miles is asking for a preliminary examination.
I'm sorry, who in our office did you speak to?
I emailed you, Ms. Williams, and received a return email as well.
Okay. I don't recall that, but okay, I'll look through my emails.
All right. You want this set for exam?
Mr. Miles is asking for a preliminary examination, yes.
All discovery is complete?
Believe so, Your Honor.
Would the people have their witnesses available on the 22nd?
We should, Your Honor. I'm sorry.
All right.
What is the defense attorney's name? He's saying he sent this email. I don't remember having a discussion. Was this shortly after the last hearing about this case? I know we hadn't made an offer at the last hearing.
My name is
Yes.
Alex Warren Green.
Okay. I'm not saying that you did.
No, I get you. How much is owing on this?
Your Honor, I believe it's just north of $6,000.
And so the exam is going to be over what's owed?
Your Honor, I might
Meaning the law that if it's charged, it's owed?
talk to my
That's
client.
okay.
I advise
We'll set
I
it.
advise him of the offer.
We'll set the exam.
Thank you.
Preliminary examination in this matter in person will be set July 22nd, 2025. That's at 12 noon. And that's before me.
Thank you, Your
If
Honor.
we set it for exam, Mr. Warren Green, you better come with something.
Thank you, Your Honor.
Court calls the case People versus Daniel Bowe.
Assistant Public Defendant Nicholas Bukovich for Mr. Bowe, who is approaching.
Your name?
Daniel Bowe.
Thank you.
At this time, Your Honor, we are requesting a brief adjournment. The prosecution has extended an offer. It's just Mr. Bowe wants to confirm that this offer won't have impact on an outside matter before accepting it. So,
Probable cause conference, July 22nd, 2025, 9 a.m.
Mr. Bowe did want me to ask if we could do a possible further out adjournment because he'll be up north for work from July 19th to August 5th. I did explain to him I could ask that, but it's ultimately up to the court.
Yeah, I'll be up by Mackinac working for about 2 weeks. And I don't want to miss court and have anything come back on me because I'm 4 hours away. If I have to make that adjustment, I will, but I'm just asking.
Oh, I know. When are you coming back now?
August 5th, I'll be back.
Any objection from the people?
No, Your Honor.
Thank you.
August 7th, 2025, 9 a.m.
Thank you, Your Honor.
You're welcome. Bond continue.
Thank you, Your Honor.
Calls case People versus Noah Adamson.
And on behalf of the people,
Lord Yagi, Assistant Public Defender, with and on behalf of Mr. Adamson, who's approaching. Could you state your name for the court?
Noah Adamson.
Thank you.
Your Honor, we are respectfully requesting an exam be set in this matter. The only
All
outstanding.
discovery, go ahead.
No, I'm sorry. The 911 call has already been requested and should be here either today or tomorrow.
that's correct, Your Honor. And if we could address on appropriate.
Preliminary examination in this matter will be set July 22nd, 2025, 9 a.m. That will be before Judge Barr. As to bound.
Your Honor, it's come to my attention that since arraignment, the defendant has made 37 calls to the victim in this case, and at this time we would be asking that his phone privileges be revoked.
Where'd you go? Oh, no. Response.
Your Honor, unfortunately, we don't have, the calls, we don't have the timings. I can't really respond without having the information underlying the argument. Mr. Adamson actually wanted me to make a bond argument today for his release, as this is the only case holding him, and he has to go back to work. He has a separate residence from the alleged victim. I will have a conversation with him about ensuring that he understands and will comply with the no contact order. I know he's been contacting his family and friends using the phone here, as he has a lot of kind of business to attend to on the outside, and his rent's coming up and all that. So I would ask for the court to reserve judgment until the exam date in terms of his phone privileges.
These are to the victim's number.
Your Honor, I believe so, Your Honor. Yes.
They are. So, Ms. Yagi, are you making a motion to reduce his bond? I mean, was that what I was hearing or not?
I am, yes.
Go ahead, response.
I would object, given the phone calls. I believe the defendant is also currently on probation for a previous conviction in circuit court for a GBH DV Act with the same victim that he was sentenced on, I believe, in February of this year. In this case, they had an argument. He grabbed her by the wrist, pushed her up against the wall. She was able to free herself, tried to use a roommate's phone to call 911. He takes the phone, hangs it up. She then tries to call 911 from another phone. He then takes that phone, hangs it up, and he entered the apartment to begin with without permission. I have concerns given that he is on height of probation for a DV offense with the same victim from this year and is engaging in that same behavior. Would ask that bond remain the same.
Anything else?
I just want to note that that there's no hold for that case, and we discussed the tether. He's in accountable choices. He's in contact with his probation officer and hasn't been violated yet. So, but nothing further, Your Honor.
Defendant's motion for bond reduction is denied. As to people's requests as to the revoking of his phone privileges, this time the court will revoke the defendant's phone privileges. Defense is entitled to and can request a hearing on that matter once they hear the calls.
Thank you, Your Honor.
Court does call the case People versus Kevin Burden.
Assistant Public Defender Jay Zollinger on behalf of Mr. Burden. And Mr. Burden, can you please state your name for the record?
Kevin Burns.
And Your Honor, all mitigation materials have been submitted. We're just waiting on consideration of that. We would be asking for 3 weeks.
Probable cause conference will be adjourned July 31st, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Thank you.
Court calls case People versus Bond Sanders.
I was done on behalf of the people, Your Honor.
And Alex Warren Green on behalf of Mr. Bond Sanders. State your name, Mr. Bond Sanders.
Deja Bond Sanders.
Thank you. Your Honor, we're asking for a preliminary examination in this case.
Discovery is complete.
I believe so, Your Honor.
People have their witnesses available the 22nd.
I believe so, Your Honor, and for the rest, we did request a 911 call in this case. It has not come in yet, but it should be here by Monday before exam.
All right. Preliminary examination in person, July 22nd, 2025 at 9 a.m. before Judge Barr. Bond continue. Court calls case People versus Andrew Burke.
And Alex Warren, agreeing on that, Mr. Burke.
Your name, sir?
Andrew Burke.
Thank you.
Your Honor, today's date and time for probable cause conference. At this time, Mr. Burke does wish to waive his right to a preliminary examination and proceed to circuit court. I'm having him sign the waiver right now.
Mr. Burke, while you're signing that, you're waiving your right to a preliminary examination, sir?
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed.
Yes, I do.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
I do.
All right. People also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Your Honor, we acknowledge receipt of the information, waive its reading, and stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
August 28th, 2025 at 1:30 with Judge Slay.
August 28th,
Yes,
2025, 1:30 before Judge Slay. Bound will continue. All right. Court calls the case People versus Matthew Fonseca. What's the deal on this one?
So he has a bond violation in this one.
Oh, I'm sorry.
That's
Morning, Judge.
Good morning.
How are you? Brian Bowling.
I don't know. What are you gonna do? No, go ahead.
Good point. Brian Bowling on behalf of Mr. Fonseca, just state your name for the record.
Matthew Fonseca.
Your Honor, when it comes to the PCCs, we were in the process of trying to reach a global resolution, but now it's come to my attention, there is a new charge that we will kind of throw into that pot to try to put it together.
Absolutely, and I'll arraign him on that charge. Mr. Fonseca, you're here on another case. You're on my complaint.
I was able to obtain a copy of the complaint this morning. I did review that with Mr. Fonseca, so for purposes of the arraignment on that charge, I would waive formal reading and stand mute.
Mr. Fonseca, you understand the nature of the charges in that case?
Yes, sir.
You understand the maximum penalties?
Yes.
And you do wish to be represented by counsel?
Yes.
All right. Defendant having waived formal reading, standing mute, court will enter a not guilty plea. So in terms of setting the probable cause in this matter.
Well, Your Honor, this would be, I guess, now 2 felony matters. It looks like that would be pending.
How come this doesn't have to dual dates?
This is the one I found online.
Okay. All right, go ahead.
We do have the bond violation as well.
Yes.
As alleged. I guess obviously.
Which are different than the new charges.
Correct.
But
so, I mean, I guess if we just could keep everything together and have a
Yes.
couple weeks, I think that would be satisfactory. I should be able to get a discovery request submitted today, and hopefully we'll have those materials prior to the next.
I'll adjourn then everything. I'll adjourn the one that's set for PCC as well as the bond violation hearing. I'll adjourn that to the 22nd, 2025 at 9 a.m. Bond will continue on that matter. On the other matter, I will set the probable cause conference for July 22nd, 2025, 9 a.m. His bond in that case what's his bond in the other one? So how many cases is he being held on right now?
It is just the bond violation, correct? Because you were out of custody, right?
Yes. Bond in this case will be set at a $5,000 cash surety at this juncture. I'll order standard conditions, including no assault behavior, possession of any weapons, no possession or consumption of any alcohol, recreational marijuana, or any illegal drugs. I will order that if the defendant is released, he is to report over to community corrections for 2 times per week drug testing.
Thank you, Judge. Your Honor, on the matter pending with the bond violation, was bond revoked?
It was.
Okay. Thank you, Judge.
So his bond will be revoked on that matter. Correct.
Okay, what time do I come back? I'll be over to see you.
Pardon? Court calls the case People versus Antonio Williams.
You took the people.
Brian Boley on behalf of Mr. Williams. Oh, he's on the screen. Your Honor.
Mr. Williams, do you have somebody that can unmute? So you can tell us, can you unmute the device?
Judge, he can hear you, but he's basically blind. So
okay.
He won't be able to, move around within that room to.
All right, Mr. Williams, if you can hear me, if you can wave your hand so that I know that you can hear me. All right, thank you, sir. What do you want?
Judge, after meeting with Mr. Williams at the jail, I believe that a competency examination is appropriate in this matter, so there should be a proposed order in the court's file for that. I'd ask you to sign it.
All right, I will sign those orders for a forensic evaluation. Ordered. I'll set a competency hearing for 90, please.
October 9th, 2024.
October 9th, 2025, 9 a.m. Bond on this matter will continue.
Thank you, Judge.
Court does call the case People versus LaShawn Charles.
And Lori Yagi, Assistant Public Defender, with and on behalf of Ms. Charles. Ms. Charles, can you state your name for the court?
LaShawn Charles.
Better.
Thank you. Your Honor, we're asking for an adjournment for further discovery in this matter.
Probable cause conference will be adjourned July 31st, 2025, 9 a.m. Bond continued.
Thank you.
Thank you.
Have a good day.
You do the same. Court calls the case People versus Darrell Frederick.
Assistant Public Defender Jay Bellinger on behalf of Mr. Frederick, who approaches.
Ms. Wiley.
Mr. Frederick, can you please state your name for the record?
Frederick.
Go ahead. And Your Honor, we've signed a waiver and I got my client's permission to sign that on his behalf.
Oh, sure have. All right. So you're waiving your right to a preliminary examination?
That's correct.
All right. You understand that's a procedure where people would have
To whatever you were talking.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
That's correct.
And you understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
That's correct. Yeah.
All right. People also waive their rights. Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Your Honor, we acknowledge receipt of information. We have formal reading, stand mute at this time.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
July 22nd, 2025.
July 22nd, 2025, 1:30, Judge Coffey.
Okay. We'll be in touch, okay? Thank you, Your Honor.
Thank you. Bond continued. Court calls the case People versus Bradley Chavez.
On behalf of Mr. Chavez, can you state your name for the record, sir?
Bradley Chavez.
All right.
We are going to be asking for a brief adjournment so we can continue plea negotiations with prosecution.
Probable cause conference, July 22nd, 2025, 9 a.m.
Thank you, Your Honor.
Thank you. Bond continued. Court calls the case, People versus Robert Gallet.
Kerma Dadush on behalf of Miss Gallet on the case ending in 713.
Morning, Roger Kilwell, Judge. I'm on case 5612.
Your Honor, we were going to be asking for adjournment in our case and a chance to address bond, please.
You're also asking for an adjournment.
Yes, I'm sorry.
All right. Go ahead and address bond.
Thank you, Your Honor. First of all, Ms. Gallet here wanted to apologize for missing her last court hearing. Since the start of this case and since her last court date, a lot of things have changed. Ms. Gallet has, first of all, now she has a phone number, a phone that we can contact her on. She has gone back on her medications. She has bipolar medications that she has to take, as well as hormones. So all of that kind of, well, it can, no, I don't want, let me word this correctly. All of that is helping us reassure, we're using that to help reassure Your Honor that she is going to show up if she is released on her own personal recognizance. She has also, she has two different caseworkers helping her. She has a CMH caseworker and a PATH caseworker. She has been approved for Avalon Housing if she were to be released. So all of that combined, her having a more secure home, having a phone number and medications. We are hoping to get a personal recognizance for that reason. She will appear. She has no intent, and there is nothing else holding her. I believe she has a 15th District Court case, but that she has a PR for that.
How did she come back in custody?
On the 15th case, Your Honor, 15th District Court case, which is just a Parks violation.
When did that happen?
I believe on the 4th or the 3rd, July 3rd. Well, that was the day.
So between March 20th and that time, what was she doing?
She was, let me talk. She was unmedicated. Her husband also has bipolar and schizophrenia. They were both unmedicated. They were both homeless, doing quite poorly. Since then, all of that has changed. Her husband is in custody, but she is really trying to do her best. She, picks up debris with the Parks and Recreation program, Give 365. Again, her meds are a very big part of her ability to, come back to court and be more stable, have stable housing. And she hopes to even start classes with Washington Community College, wants to do linguistics, just wants to start becoming better. And her meds was the first step to that, Your Honor.
Mr. Kilowald, anything?
I would just echo that argument, Your Honor.
Anything from the people? I really don't necessarily need it, but go ahead.
Two sets of concerns. I appreciate that it sounds like there's some progress being made. That case in the 15th district is an assault matter at Gilbert Hospital. I understand that things have happened in the psychiatric environment there, but that is just June 28th. And I'm concerned about some of the behaviors there and wondering, it sounds like there's been a very dramatic turnaround within a very short amount of time. I don't know if Mr. Lucia has anything else to provide proofs of some of the housing. The family is apparently of the California area, doesn't really have any ties to our county either. So I'm not sure. I'm not sure that we'll see her, quite frankly. If we do have.
So when I say I don't need it, what does that mean to you?
Well,
go ahead. No, go ahead. I'm listening.
I had options. You told me to add.
No, I didn't.
Although we don't need it. So, that's it.
Thank you. Motion for bond reductions denied. Bond will continue. I'll set the probable cause conference for July 22nd, 2025, 9 a.m. in both cases. Thank you. Court calls the case. People versus Deshaun Clifton.
Stephanie Cannon on behalf of Mr. Wood.
Oh, boy. Oh, boy.
And Your Honor, we're simply asking for an adjournment. I'm sorry,
She did? She said her name?
I did.
I didn't hear it.
Oh,
I
you want me to do it
heard
again, Your Honor?
No, really not.
Okay.
Um,
Mitigation information has been provided very recently to the prosecutor in this case. We're just asking for some time, 2 weeks, Your Honor, for her to review it and see if an offer is forthcoming.
Will the 22nd work?
It will, Your Honor.
The 31st, all right. Probable cause conference, July 22nd, 2025, 9 a.m. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you, sir. Court calls the case People versus Haruska Dennis.
Hannah Mack on behalf of Mr. Haruska Dennis, who is
Good
approaching.
morning. Again, Your Honor, Christina Costantino appearing on behalf of Mr. Haruska Dennis in the case number ending in 5076.
All right. Your name, sir?
Zachariah Haruska Dennis.
Thank you.
We're respectfully requesting an adjournment in this matter. AIM sent over a mitigation report last night, and the prosecution needs time to review it.
All right.
And I would join in that request.
All right. Will the 22nd work? I think that's what we set your last case, Ms. Constantino. Is that right?
Yes, Judge, I would ask for the 22nd, given he is in custody.
Probable cause conference will be adjourned July 22nd, 2025, 9 a.m. Bond will continue. And Ms. Constantino, I will tell you, I miss you too. And Mr. Allen told me I wasn't very nice in saying what I said the last time. So I don't know what's going on there, but he was kind of yelling at me.
Well,
So-
thank you, Mr. Allen, and thank you, Judge. I appreciate you changing your mind. I hope to see you soon.
Yes, ma'am.
Thank you.
Thank you. Court calls the case, People versus Christopher Cummings IV.
Assistant Public Defender Chelsea Vergils with and on behalf of Christopher Cummings. Please state your name.
Christopher Cummings.
Your Honor, we are requesting an adjournment today. Since his last court date, we did receive discovery. We're asking for time to review that and consider the offer that's been made in this case.
July 31st, 2025, 9 a.m. Bond continue. Thank you. Court does call the case People versus Mark Hubbard.
Alexander on behalf of the people, Your Honor. Hannah Mack on behalf of Mr. Hubbard, who is approaching, Your Honor. Please state your name for the record.
Mark Hubbard.
Your Honor, at this time, we respectfully ask to set this matter for a preliminary examination, and all discovery is complete as far as we are aware.
People have their witnesses available the 22nd.
We'll do our best, Your Honor.
Preliminary examination in person will be set July 22nd, 2025 at
12 p.m.
12 noon before me. Bond will continue.
Judge.
Court calls case People versus Devon Julia Martinez.
Stephanie Cannon on behalf of Ms. Martinez, Your Honor, who is appearing via Zoom.
Devin, can you state your name for me?
Devin Julia Martinez.
Thank you.
Your Honor, Ms. Martinez was recently, I believe a week or two ago, evaluated by the Forensic Center because in her other cases, she has forensic order requested. I am filling out the paperwork to get one filed in this one as well. However, we have not received the evaluation back. Upon receipt of that, my client is indicating she does want to waive. However, I don't believe the court will do anything.
I won't.
But I want her to hear that, won't be able to do so.
When is that other case set? Do you know?
She is set in front of Judge Hamoud. I believe her next court appearance is on July 28th.
All right. And you're filling out the paperwork because you want, all right.
I'm just gonna have the order placed in this file as well, Your Honor.
So I will order a forensic evaluation. I will set her comp hearing on this case, October what?
October 9th.
October 9th, 2025 at 9 a.m. If the report comes in before then, certainly we can move that date up. All right.
And I will explain that to my client, Your Honor.
All right. Bond will continue.
Thank you.
Yes. And when they get that. Who's filling, thank you. Who's filling out the order? I can really? Oh, it's gonna be a minute here. Why is that taking so long?
Well, Your Honor.
Why, not you, her. What is she doing? What are you trying to help her? Just slowly though, right? Court calls the cases of the people versus Chad Jones.
Brenda Mackey on behalf of Mr. Jones, who's approaching. Please state your name for the record.
Chad Jones. Thank you.
Your Honor, we're respectfully requesting to adjourn this matter pending drug court eligibility.
All right. Has he already been interviewed yet?
Not yet, Your Honor.
Not yet?
The referral was sent in yesterday.
Of course it was. All right. I will adjourn these matters then to July 31st, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court calls the case People versus Sean Hardman. Good morning. What? Hold on. So why are you with Douglas? Wow. I asked the question. Actually, what I was going to say, what's Zen to do to you? Oh, okay. All right. No, I thought you might have requested a transfer. Permission to practice is granted. Go ahead.
Good morning, Your Honor. Sydney Rushing, appearing on behalf of Mr. Hardman. Mr. Hardman, can you please shake your hand, let the deputy know need to be unmuted and state your name for the record?
Oh, yeah, hold on to that blanket. Don't worry about it.
Okay, thank you. Your Honor.
That's him. We're good.
Your Honor, at this time, we are requesting a brief adjournment. There is some outstanding discovery that I will need to get and review with my client. So we are just asking for an adjourned PCC date.
All right. Probable cause conference, July 22nd, 2025, 9 a.m. Bond continue.
Your Honor, may I briefly address bond?
Sure.
I did tell the people I was going to be doing so. Mr. Hardman's bond is currently set at $1,000, 10%. So $100 is what would need to be posted. I'm asking Your Honor to consider reducing that down to a personal bond. This case the incident date is from November 2nd, 2023. The warrant on this case wasn't signed until September 26, 2024. And then the arraignment on this happened on 6/30/2025. He's actually currently in Judge Conkey's drug treatment court. So this isn't a new case. It's not a violation, or I guess I should say it wasn't a violation. It will be if he pleads up, but it's not new. So I'm just asking for Your Honor to consider reducing it down to a personal bond. He does have stable housing.
Is this the only thing holding him?
Yes. After this, Judge Conkey isn't addressing the bond on that case until this bond's addressed. So he has court on that on the 20, is it the first?
So
I believe on the 26th.
Well, is this a bond violation?
I think at this point, since it's been issued, yes, but she was waiting to see what the court was going to do on this bond before she addressed her bond. He had court earlier this week. Okay. She put it out for us to address it here first, and then she's going to address it in her court.
Okay, just so that I have the timing correctly. He was in drug court.
Yes.
This case, the allegations in this case occur.
They occurred prior to him going into drug court. So this case, it took a while for the warrant to get signed.
Gotcha.
When the warrant got
that's
signed.
what I was trying to make sure of. So
yeah.
This case, I'm not clear how it would be a violation. Okay, I get you. That's what I was trying to figure out.
Yes.
Dates weren't matching up for him.
I think technically it can be, but I don't think it's going to be viewed as it since the incident happened prior.
Any response from the people?
It's usually that it's a mobile case, it's not assaultive, so we would leave it in the court's discretion. The incident does predate the other incidents in the circuit court cases, and actually isn't showing any hold on.
Alan, doesn't she seem much nicer since she's not with Zenda? I say that out loud. I'm sorry, Miss Zenda, I didn't mean it.
They know your gate or no?
All right, here's what I'm gonna do. I will, under the circumstances, and since he's in drug court, I will grant the defendant's motion. I'll reduce his bond to a $1,000 personal recognizance bond with all its conditions of no drug use.
Thank you, Judge.
All right.
A 2 minute thing.
All right.
Thank you, Judge. I'll see you on the 22nd.
Thank you.
Have a great day, Judge. Have a
You
great
do the
staff
same.
as well.
Okay, he's all set. Court calls the case, People versus Nicole McCauley.
Maybe it works like that for people.
Hannah Mackey on behalf of Mrs. McCauley, who is approaching.
So in there, you don't have.
Nicole McCauley.
Yeah, you're all set, sir.
We're requesting an adjournment in this matter, Your Honor. We are waiting for media discovery.
Probable cause conference will be adjourned July 22nd, 2025, 9 a.m. Bond continue. Court calls case People versus Stefan Wainwright. Why do I have so many down there? Jimmy.
And Alex Warren Green on behalf of Mr. Wainwright, who is on Zoom, Your Honor. Mr. Wainwright, can you state your name for the court?
Yes, Stefan Dallas Wainwright.
Thank you. All right. Your Honor, I've completed an adjournment request form. We are asking for an adjournment to continue our negotiations with the people.
July 22nd, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
So the People versus Richard Morende.
Alexander on behalf of the people, Your Honor.
Good morning, Your Honor. Megan McDonald on behalf of Mr. Morandi, who is present on Zoom this morning, and we consent to have this hearing via Zoom.
Sir, can you please state your name?
Yes, good morning, Your Honor. My name is Richard Morandi.
Thank you.
Your Honor, for the purposes of the PCC today, we have not yet received discovery in this matter, so I would ask for an adjournment of this, please.
All right, he's out of custody. So
Yes, he's out of custody on bond.
seriously. I'll adjourn probable cause conference to July 31st, 2025 at 9 a.m.
31st, Your Honor. Okay, at 9 a.m. Thank you so much. That works for us.
Thank you.
Thank you, Your Honor. Have a great day.
Thank you. You too. Court does call the case. People versus Invitme Agbu Zulu.
Alexander on behalf of the people, Your Honor.
Stephanie Canna on behalf of Bititmi Guzulu.
Guzulu Alexander.
Your Honor, the E is silent in his name.
Okay.
Yeah, let you know. Oh, Your Honor, we are adjourning this case.
You know what?
For mitigation purposes, I do
Let me
understand.
deal with her one day a week.
You got lucky.
One day. One day. I mean, you were here 2 days.
You got lucky.
So I'm over it.
There you go.
And Your Honor, if we could address bond. Good.
And Your Honor, we understand he also has a bond violation.
Yep. Go ahead, Ms. Senda.
Your Honor, this would be a further violation of his bond as he third parties from the jail, and I'll just paraphrase one of these conversations. As long as she doesn't show up, then they'll just knock the case out. All right, do you want me to tell her not to show up? Well, she already said she's not. All right, I might shoot a text and say, hey, don't show up to that court thing. He says, no, I think you should drive there. Ain't nothing wrong with you going there. He says, all right, talk to her in person.
So I have concerns he's calling third parties, having them talk to the victim, go to her residence, see her in person to tell her not to come to court. And I would be asking that his phone privileges also be revoked.
Any response?
Your Honor, I have talked to my client about that. I was informed that this did happen. I actually don't have a copy of those. However, I trust that the prosecutor's office will be sending me those. Your Honor, my client is understanding that he cannot do that. He will not be doing that. And he is asking that his phone privileges remain in place. As to the prior violation, Your Honor, my client works for the property management. That's how they have the apartment that they live in. So on that date in question for that particular violation, he did not go to the resident. He was not in the residence. He went to the shed, we'll call it a shed, located on the property. He retrieved his tools and then he left. So
He could have done that with a civil standby.
he didn't go into the apartment, Your Honor.
Yeah, but I'm real concerned right now because the phone calls clearly indicate an attempt to get in contact with this victim, and then he's in the vicinity violating his condition. But you can go on if you wish, Ms. Camp.
No, Your Honor, I believe the court has all the information they need.
His bond in this matter is revoked based upon the bond condition, and his phone privileges are also revoked.
Thank you, Your Honor.
Thank you.
Oh, thank you, Your Honor.
Your Honor, what was the new date?
Was that it? I did not. You're looking for an adjournment. Probable cause conference, July 22nd, 2025, 9 a.m.
Thank you, Your Honor.
Thank you.
Court does call the case People versus Ryan Piper.
And Alex Warren Green on behalf of Mr. Piper. Mr. Piper, can you state your name for the court, please?
Ryan Pieper.
Your Honor, today's date and time for a probable cause conference. In light of Mr. Pieper's restoration to competency, I would be asking for a preliminary examination in this case.
Discovery is complete then.
Believe so, Your Honor.
And would the people have their witnesses available the 22nd?
Yes.
Preliminary examination in person, July 22nd, 2025. That's Barr. 9 a.m. before Judge Barr. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the case People versus London Daughtery.
Andrew Children, on behalf of people.
Hannah Mackey on behalf of Mr. Daughtery, who is approaching to my right. Your name for the record.
London Daughter.
Your Honor, we respectfully request to adjourn this matter for further investigation,
For what?
to look into the case a little bit more.
This courtroom hearing took a serious turn when prosecutors revealed that a defendant had allegedly made 37 phone calls to the victim while already facing a no-contact order. Noah Adamson was scheduled for a preliminary examination, but the prosecution raised an urgent concern. According to the prosecutor, since his arraignment, Adamson had made 37 calls to the victim's number, and the state asked the court to revoke his phone privileges. The defense pushed back, explaining that Adamson also used the jail phone to communicate with family and friends and needed to handle responsibilities outside of custody. His attorney also said he would speak with him about following the no-contact order. But then, prosecutors revealed an even more troubling detail. They alleged that Adamson was already on probation for a previous domestic violence offense involving the same victim. The prosecution described an earlier incident in which he allegedly grabbed the victim by the wrist, pushed her against a wall, and took away phones when she attempted to call 911. That changed everything. The defense argued that the phone records had not yet been provided and asked the court to wait before taking action. But the judge wasn't convinced. The court denied the request to reduce his bond and then made the decision that could immediately affect his ability to communicate from custody. His phone privileges were revoked. The judge did leave the defense an opportunity to request another hearing after reviewing the actual calls. But the message was clear. If a court orders someone to have no contact with an alleged victim, continuing to make contact can have serious consequences. And this hearing showed